Okay, picture this. You're running your business, maybe it's mid-size, maybe a startup that's really taking off, and then, boom, a letter arrives, tax authorities, massive assessment.
Yeah.
And you look at it and you think, this can't be right. Maybe it's based on an error, maybe, totally illegal, but the number itself, it could sink you instantly. Mm-hmm. So your first thought, your gut reaction is, get to court, file something, stop this collection now until we figure it out.
Right.
You want that pause button.
Absolutely. That's the natural instinct. But what if the law basically says no? What if there's a legal wall built specifically to prevent you from hitting that pause button?
And that wall is what we're digging into today. We're taking a deep dive into the no injunction rule in Philippine tax law.
Right.
This rule, it's like a legal shield for the government, generally stopping courts from issuing injunctions, those stop orders, when it comes to collecting national internal revenue taxes.
And it's really a cornerstone principle. The idea that revenue collection needs to happen smoothly and quickly, it's deeply embedded. It all ties back to that constitutional idea that, well, taxes are the lifeblood of the government.
Okay, lifeblood doctrine. We hear that phrase a lot. For someone maybe not deep in tax law, what does that really mean in practice, like day to day for the government?
It means the government literally needs taxes to exist and function. Simple as that. Think about public services, infrastructure, salaries, everything. If courts could just halt tax collection whenever a taxpayer disputed an assessment,
Chaos.
Total chaos. It would threaten the government's stability, its ability to operate. So the state needs, fundamentally, an unimpeded way to get that revenue in the door.
Got it. So our mission here is clear.
Yeah.
Let's unpack this rule. Where did it come from? Why is it there? And crucially, let's get into this really important distinction the Supreme Court made about where it applies. Because that changes things, doesn't it?
It absolutely does. It's a critical nuance.
All right, let's start with the basics. Where did this rule actually originate? Was it judge-made law, or is it written down somewhere specific?
Oh, it's definitely written down. It's statutory. Its main home is in the National Internal Revenue Code, the NIRC, specifically the 1997 version. That law lays out the policy pretty clearly. Courts generally shouldn't interfere with collecting national taxes.
Okay, 1997. That's a while ago now. Has thinking shifted? Maybe newer laws tried to balance it out, give taxpayers a bit more breathing room prepayment? Or has it gone the other way?
It's actually gone the other way. Subsequent laws have consistently doubled down on it. Think of the NIRC as the foundation. Then you have major pieces of legislation like Republic Act 10963, that's the train law everyone knows.
Right.
And even the very recent Republic Act in 1976, the Ease of Paying Taxes Act, or EOPT. They've reinforced the principle.
Wait, even the Ease of Paying Taxes Act, that sounds like it should make things easier for the taxpayer, maybe give them more leeway.
You'd think so, wouldn't you? But easier in terms of process, yes. Modernization, digitalization, sure. But not easier in terms of challenging the collection itself before paying. Even EOPT reinforces the idea that you challenge the assessment through specific routes, but you don't stop the collection via injunction for national taxes. It shows this enduring commitment, really, to keeping that revenue stream protected.
So a clear consensus across different times and laws. It seems this protection is seen as absolutely vital. Let's explore why then. Why the extreme strictness? If the assessment might be wrong, why not wait for a court to sort it out first? What are the main justifications?
Well, it's not just one reason. It's multi-layered. You can break down the objectives into maybe 4 main areas. It's about stability, efficiency, integrity, and that core constitutional idea. First off, just pure operations. Ensuring efficient tax collection. The government runs on a budget, projects need funding now, delays caused by injunctions could grind everything to a halt. Second, and tied to that, is protecting the government revenue itself. Shielding that inflow ensures financial stability. It means funds are there for schools, hospitals, roads, all the essential stuff. Without that predictability, planning becomes impossible.
Okay, that makes sense from a fiscal stability point of view. If every big company could just tie up huge tax payments in court for years,
yeah,
the treasury would look pretty bare. What's the third reason? Maybe less obvious.
The third is about preventing abuse of the courts. The rule discourages taxpayers from filing, let's say, frivolous lawsuits just to buy time or avoid paying altogether. It preserves the integrity of the system by saying, look, there are ways to challenge this, but stopping the collection isn't one of them for national taxes. It stops people from gaming the system just for delay. And the fourth reason brings us right back to where we started. Upholding the lifeblood doctrine. It's the legal system reinforcing that fundamental idea the government needs taxes to survive, And that need generally overrides the taxpayer's desire to delay payment during a dispute.
Okay, those are compelling reasons from the government side. But how is this actually played out in the courts? I mean, has the Supreme Court ever made an exception? If a taxpayer comes with really strong proof that the BIR assessment is just plain wrong based on a clear error, does the court ever say, okay, this time we'll issue an injunction?
You know, the case law is remarkably consistent on this point. The Supreme Court almost always upholds a rule when it involves the BIR and national internal revenue taxes. They stick very strictly to what the NIRC says. The sanctity of tax collection is paramount in their rulings.
But what if it's not just erroneous, but actually illegal? Like the BIR applied the wrong law entirely. Still no injunction.
Generally, still no, and that's the really tough part for taxpayers. The court has said time and again, even if you allege the assessment is arbitrary, wrong, illegal, the prohibition stands firm for national taxes.
Why? What's the justification for that?
Their reasoning usually points back to the NIRC itself. The law provides other ways to fight the assessment. You can protest it administratively, you can pay it, and then file a claim for a refund. Those are considered the proper channels. The courts are basically saying, use those remedies, don't ask us to stop the collection process itself for national taxes.
Okay, this is leading us right to that critical distinction you mentioned earlier, the nuance. If the rule is so absolute for national taxes, it feels logical it would apply everywhere, national, local, provincial taxes, all government revenue, right?
That's where the logic hits a wall, and it's the absolute key takeaway here. The rule is not universal. The Supreme Court made a very significant clarification. They drew a line. The prohibition against injunctions. It applies only to national internal revenue taxes, the ones the BIR collects.
Only national taxes. So
Right.
What's excluded then? Where does the rule not apply?
Local taxes. Taxes imposed by provinces, cities, municipalities. There was a landmark case, GR number 166134, where the Supreme Court explicitly said the NIRC's prohibition on injunctions does not cover local taxes.
Wow.
The court recognized that local governments operate under a different legal framework, the local government kind primarily, not the NIRC in the same way.
So let me get this straight. A court can issue an injunction to stop a city or province from collecting a disputed local tax, assuming the taxpayer meets the usual requirements for an injunction, like showing potential irreparable harm.
Exactly. That avenue is open for local taxes. If you're fighting City Hall over a questionable business tax, you might be able to get a court to pause the collection. But if you're fighting the BIR over national income tax or VAT, that door is generally closed.
That distinction is huge for anyone dealing with tax issues. It adds predictability, I guess. You know which battlefield you're on?
Precisely. It clarifies the rules of engagement, so to speak. National engine keeps running, no stalling allowed. Local level, different checks and balances apply.
Okay, let's shift gears a bit. Let's talk about fairness, practicality, the real-world impact. This system, especially the national part, seems necessary for the government, sure. But it puts taxpayers in a really tough spot, doesn't it? How can we square this with fairness, especially for, say, a small business facing a potentially bankrupting national assessment that might be totally wrong?
That's the core tension, isn't it? Fairness here is viewed through two lenses. For the government, and by extension the public relying on services, the rule is seen as fair because it ensures that stable, predictable revenue keeps flowing. It prevents paralysis. That stability benefits everyone in theory. But for the individual taxpayer, it's undeniably harsh. The NIRC's idea of fairness isn't preventing the collection, it's providing remedies after collection. The system says, we're not denying you justice eventually, but you have to follow our process. You protest, you appeal, maybe you pay, and then sue for a refund.
Right, the infamous pay first, question later system. Which, let's be honest, feels fundamentally unfair if you genuinely believe the assessment is wrong and paying it now could destroy your business. Knowing you might get a refund years down the line doesn't help you make payroll next week.
Exactly. That's the practical challenge.
So what are the practical benefits that supposedly outweigh this immediate hardship for the taxpayer?
Well, from that macro national perspective, the main benefit is avoiding fiscal chaos. Widespread injunctions against national taxes could genuinely paralyze the economy. Imagine the uncertainty if the government couldn't rely on its projected revenue because half of it was tied up in court disputes. And there's an administrative efficiency argument too. It lets the BIR focus on assessing and collecting rather than constantly diverting resources to fight off preliminary injunctions and TROs in court, many of which might just be delay tactics. It streamlines their process, aiming for speed and collection.
But we have to acknowledge the challenges, the trade-offs. That immediate financial hit for a business facing a huge contested national tax bill that's not trivial.
It's the biggest challenge, absolutely. It's the sharp end of the rule. Even with those other remedies available later, the need to find the cash or assets up front can be a massive, sometimes insurmountable hurdle, especially if the assessment turns out to be arbitrary or just plain wrong. You could win your case years later, but your business might already be gone. And interestingly, the fact that local taxes do allow for injunctions kind of highlights this dilemma. It shows that the legal system itself recognizes that a total ban isn't always necessary or appropriate for all types of revenue. It suggests there's room for different approaches depending on the context.
This has been really insightful. So let's recap. We've got this no injunction rule firmly planted in statute, NIRC, train, EOPT, all reinforcing it. Its purpose is clear. Protect government revenue, ensure efficient collection, prevent abuse, uphold that lifeblood doctrine. Basically, keep the national financial engine running smoothly.
But, and this is the crucial but, its reach is limited. It applies strictly to national internal revenue taxes collected by the BIR.
Right. Local taxes are a different story, thanks to court clarifications. Like in that GR number you mentioned, injunctions are a possibility there.
Exactly. That distinction is key. GR number 166134 really drew that line clearly.
So the system ensures stability for the government, but imposes that really difficult pay first, question later reality on taxpayers dealing with national assessments. Which leaves us with a final thought, perhaps, for you, the listener, to mull over.
Given this tension, the government's need for immediate funds versus the potentially devastating impact on a business forced to pay a contested amount up front, maybe the focus shouldn't just be on the rule itself, but on what happens after payment.
Meaning?
Well, if the system requires payment first, shouldn't there be immense pressure now to make the post-payment remedies, like the refund process, incredibly fast and efficient? So if a taxpayer is proven right, they get their money back quickly, before the delay itself causes irreparable harm. Is the current system of remedies strong enough or fast enough to truly balance the scales against the harshness of pay first? Something to think about.